Discrimination in the Workplace by Sherry Barnes. Is the request for sexual favors that an employee has not consented to and finds offensive. For sexual harassment to exist, the victimized employee must be a member of a protected class, that is, a woman or man. The complaint must be gender related. The employee must have not consented to the sexual advances. The harassment must be based on sex. The conduct complained of must have an effect on the employee's job. The harassment must have occurred during employment. Is liable for sexual harassment. Vicarious liability renders responsible for their supervisor's tangible employment actions undertaken in return for sex with a subordinate or a subordinate's refusal to engage in sex. Persuasive. The alleged act of sexual harassment must be severe enough to create an abusive work environment and to dispute the victim's employment. Casual comments or insignificant events that are isolated or happen only intermittently are insufficient. 1 refers to a person's roots, that is, the country in which the person or the person's ancestors were born. Origin discrimination is as follows. The employee belongs to a protected class. The employee wanted to retain or obtain. The employee was terminated or the applicant was refused employment. Termination or refusal to hire occurred because of the employee's or the applicant's national origin. Of the Civil Rights. Title V of the Civil Rights Act of 1964 is a federal law that prohibits employers from discriminating against employees on the basis of sex, race, color, national origin, and religion. It also ended unfair voter registration requirements and racial segregation in schools, at the workplace, and by facilities that served the general public. Discrimination in the work situations. The law forbids discrimination when it comes to any aspect of employment, including hiring, firing, pay, job assignment, promotions, layoff, training, fringe benefits, and any other term or condition of employment. Million judgment in sexual harassment and discrimination case. Michael Murcia, a Japanese American, was one of Microsoft's top salesmen in Austin, Texas, who has worked for the company for the last 17 years. He was a single dad and had a sexual relationship with Lori Olds, a co-worker, which ended at his request. In 2007, she became his direct manager. And when Olds had a sleepover with Tracy Rummel, a marketing consultant whom Microsoft would soon hire, they hatched a plot where Rummel made a false charge that Murcia had sexually harassed her. Rummel passed on the phony claim to her boss, National Sales Director David Tandrum, and then to his supervisor, Eddie O'Brien, a Microsoft vice president. The managers created the hostile workplace. Murcia noticed he was being treated differently at work. Tandrum chastised him for missing a deadline by only 3 hours and criticized him for not doing his job well. He and VP O'Brien called Murcia's customers trying to dig up dirt about him. Olds made disparaging remarks about Japanese people and questioned his green card status. Murcia filed an international complaint with the company. 2 weeks later, now employee Tracy Rummel filed a formal sexual harassment charge against him. An HR worker who was in on the scheme helped her write the complaint. She had conspired with Olds to file the trumped-up charges. After 16 straight months of abuse, Murcia sent a letter saying Microsoft had terminated him. Illegal to fire someone because they do not want to engage in sexual behaviors. It's also illegal to create a hostile work environment because you are upset with them.